Section 2 of the Voting Rights Act is literally facing a life or death moment. The Supreme Court can potentially remove the opportunity for private plaintiffs to be able to sue pursuant to that section. And that section says that you can't have like a voting qualification or a voting practice that discriminates on the basis of race or on the basis of color. And so when you hear that and you think, well, who's going to be able to sue on my behalf? And you're told it's the federal government, the Department of Justice. And we all know that Pamela Jo Bondi is not going to prioritize illegal voting practices, right? In terms of suing on behalf of people. And that is why I wanted you to meet Jacqueline De León. She is the senior attorney who's litigating cases on behalf of NARF, the Native American Rights Fund. And as you can hear, it's on behalf of tribes from across the United States of America. And the Native American community has been subjected to horrific voter suppression for decades. And yet I feel like we don't talk about it enough. We don't amplify for people to understand enough about what is happening. And so I invited Jacqueline to the Katie Phang News Channel to have a conversation about the petition that she just filed in front of the Supreme Court of the United States on behalf of the Chippewa in North Dakota and another tribe and some private plaintiffs, and to talk about why we need to be focusing on her case and other cases that involved Section 2 of the Voting Rights Act, because there could very well be the elimination of that subsection. Take a listen. And now I have the privilege of welcoming Jacqueline De León to the Katie Phang News Channel. Jacqueline, it's good to see you.
It's so good to see you.
Jacqueline, so why don't we start straight out of the gate to inform our viewers what NARF is, the Native American Rights Fund?
Yeah, the Native American Rights Fund is the nation's largest and oldest nonprofit law firm dedicated to advancing the rights of Native Americans. We have a large mandate, a big breadth of issues that we cover, everything from voting rights, where I'm the practice group lead, to natural resource protection, tribal sovereignty protection, really digging in on education, civil rights, and a whole breadth of issues that affect the Native American community.
And can you actually describe, does this cover all of Indian country? Like, what are we talking about?
Yeah, so we're a national organization. We fight on behalf of all of Indian country, and our cases vary from, individual tribal plaintiffs to really representing all of Indian country on key issues, especially as they relate to tribal sovereignty.
Before we get into the latest battle that you are waging at the United States Supreme Court, which is a case that, to be very clear, impacts all Americans, not just those that are from tribal lands, you and I had the pleasure of getting to know each other when we spoke on a panel with current Lieutenant Governor of Minnesota, Peggy Flanagan. And we also spoke because I've always wanted to amplify what is going on when it comes to voter suppression for Native Americans. I am appalled that there's not enough light that is shed on exactly how abhorrent the tactics are to suppress the vote when it comes to tribal lands. Talk about why it's important for people to understand the work that's being done at NARF right now.
I think that the average American would really be shocked at how difficult it is to vote in Indian country. Too often, polling places of registration are too far away, right? It's sort of basic in that sense, right? Native Americans aren't getting equitable access to those key resources, and they're also facing a ton of difficulty accessing being able to even get there, right? That's because the roads are poor, they don't have residential mail delivery on their homes, and often they have to travel those same significant distances to get to a post office. And so Native Americans have to expend really disproportionate and unfair resources even to be able to access the vote. And so across the country, we're seeing this remarkably consistent picture where it's altogether too difficult to vote in an Indian country.
Jacqueline, for example, and this is something that I learned courtesy of you, so I'm so grateful for the knowledge that you're willing to share. The Trump and the Republicans' attempts to curtail mail-in voting, for example, talk about why it just creates such a huge obstacle, because it's not that easy to be able to just go to a polling place when you're living in Indian country.
Yeah, I mean, that's right. I think that we are always a proponent of more options, and that's because our options are too few, right? There are significant issues accessing mail-in ballots in Indian country because there is no residential mail delivery too often, right? And so what people usually do is the person with the resources can go, they can take the roadworthy vehicle over the dirt road in November, right? Go all the way to the post office, pick up ballots for folks, come back, have ballots filled out, and then that roadworthy vehicle is taken again to drop those ballots off, right? These are people that are just trying to make do really with untenable and unfair situations.
Talk about IDs, because Trump is on this crusade to make sure that you show a specific type of identification for purposes of being able to not only register to vote, putting aside the whole Save Act name issue, but then to actually go on election day to be able to do it, assuming you cannot do mail-in voting. Why is that also a unique problem for your community?
I think what people have to remember is that we're not necessarily against ID, right? What we are against are cutting out people based on the type of ID that they have. Mm-hmm. And I think too often in Indian country, either tribal IDs are left out or people start getting clever and they add requirements like a residential address to the ID when they know full well that the homes across Indian country often lack those residential addresses. And in fact, we've seen that tactic used in places like North Dakota, specifically after Native Americans flex their political power. They will add an ID requirement that say requires that residential address. And quite predictably, Native Americans are cut out of being able to vote. And really, that is a modern day literacy test. And I think that voter IDs can often be manipulated to cut out voters that one side may deem undesirable.
And, this is not the right to vote, the ability to vote more accurately. This is something that was a very recent acquisition for the community.
Yeah, so I mean, really, citizenship was conferred upon Native Americans in 1924. So that was just 100 years ago. And, after that conferral, Native Americans continued to be harassed and cut out of the voting populace in states like New Mexico, Arizona, Utah. Native Americans were explicitly prohibited through state laws and constitutions from being able to vote. And it really wasn't until the Civil Rights Act, until the Voting Rights Act, that Native Americans started to get access to the franchise.
So, Jacqueline, let's talk about this huge case that you've just done, this big filing in front of the Supreme Court. It's the Turtle Mountain case, and talk about why it's so important for all Americans to understand what's at stake.
Yeah, well, unfortunately, the Supreme Court has multiple avenues this term to really undermine the Voting Rights Act and potentially really devastate, and it's an existential threat to the Voting Rights Act. There's really issues with how the court can go about making it so that the Voting Rights Act no longer is a viable tool for protecting people from discrimination. And so the Turtle Mountain case is a case about the Turtle Mountain Band of Chippewa Indians, the Spirit Lake Nation, and individual plaintiffs that was brought by NARF and our partners, CLC, and individual lawyers that is dedicated to trying to impose fair maps in North Dakota. The state legislature passed maps that were unfair. And in fact, in front of a Trump-appointed judge, they were found to violate the Voting Rights Act, sort of egregious violations of the Voting Rights Act. And the state, rather than really engage in the merits of whether, on appeal, they decided instead to advance a novel theory. The Eighth Circuit has been issuing radical opinions, and it issued two findings, one in a case other than ours that found that contrary to 60 years of precedent that the Voting Rights Act did not have a private right of action, meaning that individual plaintiffs could not bring lawsuits under the Voting Rights Act. And then in our case, found that likewise, Section 1983 could not constitute a cause of action. So effectively, the Eighth Circuit has cut out private litigants, meaning tribes, individuals, organizations, from being able to bring cases under Section 2 of the Voting Rights Act, instead claiming that only the Department of Justice can bring those cases. Of course, we know that the Department of Justice can be politicized. We know that the Department of Justice's resources can be cut. And in fact, right now, we know that out of the over 30 attorneys that previously populated that section, there are only about 3 left. And so we know that the Department of Justice is not suited, or nor does it have the temperament right now to bring cases on behalf of the disenfranchised. And so instead, individual litigants are the ones that have been bringing, in fact, over 90% of the cases, even successful cases. And so to cut off that avenue would devastate the Voting Rights Act. And so we are currently have a cert petition before the Supreme Court to hear our case.
Okay, so we're going to break that all down because that is some heavy stuff. And you will see that the people that are subscribers to this channel, that we've gone to law school together. And so we definitely want to learn more because knowledge is power, as I like to say. So you filed a cert petition, which my viewers know means you've asked the Supreme Court to take this case after that adverse ruling you got from the Eighth Circuit, right?
That's right.
Okay. And then just to refresh everybody's recollection, Section 2 of the Voting Rights Act, and again, whatever is left of it, because the Supreme Court has been slowly and in big ways chipping away at the Voting Rights Act. Section 2 provides that no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in the denial or abridgment of the right of any citizen of the United States to vote on account of race or color. So that section of the Voting Rights Act, previous to this recent decision from the Eighth Circuit, allowed private plaintiffs, meaning you, me, people that have standing, which my viewers understand, people that actually have the ability to bring a cause of action pursuant to Section 2 of the Voting Rights Act. They were previously able to do this until the Eighth Circuit said, psych, no dice, private plaintiffs can't do it. We have to trust the Department of Justice. But I will tell you, Jacqueline, my viewers also know that the DOJ Civil Rights Division is being run by Harmy Dillon, who we all know is very busy meddling in gerrymandering in Texas and other states. So, Jacqueline, talk about why, I mean, this is wild, right? Because this would literally turn the ability to do voting rights on its head, right?
That's right. Yeah. No, I mean, I think that it's really no solution, right? I think that it would be it would effectively null the Voting Rights Act for this country. I don't think it's an overstatement to say that this case is an existential threat to the Voting Rights Act.
Jacqueline, so this is why not only I wanted you to be on so people could learn more about you and the Native American Rights Fund and the work that you guys are doing, but this case. When do you think you could even hear if the Supreme Court's going to grant cert on this?
Well, so I think that there's a variety of avenues that the court may take to address this issue. So it may not grant cert in our case, but there are other cases like Milligan, other cases, Mississippi recently filed a case where the court is going to have to address this case to reach the merits. It's going to have to find whether or not there is a private right of action. And so I think that it's very high chance that the court grants our case, but there's also very high chance that they deal with it in a different way. But the court will be addressing this term.
And let me be clear. North Dakota is home to 5 federally recognized Indian tribes. And what's at stake in your case is in 2021 in North Dakota, the state redrew the boundaries of its legislative districts, reducing the number of majority Indian seats in the northeastern part of North Dakota from 3 to 1. I mean, Jacqueline, this is just, though, yet another example of state legislatures fiddling with, manipulating, redistricting. I mean, this is the whole point of what's happening in Texas. And now we hear in Missouri and even in Florida, we got a governor who wants to redo the maps here too, again.
I think what's the really important takeaway from all of this, I think North Dakota Fine is a really good example of this, is that this isn't just about politics. This isn't just about political control. This is about race and racial discrimination. Yeah. The three seats that we're talking about are not going to constitute the majority of the state legislature. They're not even going to touch the supermajority that Republicans have in North Dakota. Rather, what North Dakota is fighting against is just the very idea of Native representation. They are really just sort of pushing back on any type of engagement from Native Americans in the state. And this started all the way back, like I mentioned, over that voter ID law. And it has continued over time. The state has been aggressively trying to push Native Americans out of the electorate. And that is something that is the type of racial discrimination that the Voting Rights Act was designed to combat against. And that's why it's incredibly critical that we still have access to that tool.
Which kind of almost leads me to believe that maybe the Supreme Court would grant cert on this, because it is a uniquely positioned case versus the straight partisan political redistricting that we're seeing when it comes to just the party stuff and maybe some of the other litigation.
Yeah, I mean, I think many of the cases are really about this racial discrimination, right? But I do think that our case is where this controversy originated from. It's the Eighth Circuit that again has been issuing these incredibly unprecedented positions, and our case is a really, I think, clear-cut vehicle of how you can have a uncomplicated violation of the Voting Rights Act and private litigants that are blocked from being able to enforce it.
I mean, in your previous explanation of this Turtle Mountain case, you provided a statistic too that I really want to kind of underscore for the people that are tuning in. One, again, this particular section 2 of the Voting Rights Act of the VRA allows for private plaintiffs to be able to sue for relief. And you said currently it's about 90% of these cases that are brought by private plaintiffs. So to be clear, if the Supreme Court says that this part of the Voting Rights Act is not legal anymore, then we'd have to rely solely upon governmental agencies to be able to fight for our rights?
That's right. So really, private litigants have been the one that have been bringing these cases all along. If your right to vote has been abridged, right? You're aware of it and you're motivated. That's why people that have been discriminated against have been bringing these cases for decades. Yeah. And the Department of Justice has always taken, one, a far more conservative approach, and two, simply doesn't have the resources to actually pursue every case as it exists. And now we can see that department can be politicized, and that department also can be gutted. And so really, there's no reason to think that if the Department of Justice was the only vehicle for enforcing the Voting Rights Act, that would be effective.
Yeah, and I think you're being very gracious by your characterization of this Department of Justice under Pamela Jo. I think that, and what's clear too is Pamela Jo Bondi is the Attorney General, but she doesn't run these individual kind of departments. She's not like a department head. Like I said, we've got Harmeet Dillon, who's running the Civil Rights Division right now, et cetera. But I mean, you also dropped the statistic that the division that could theoretically at DOJ bring lawsuits on behalf of the Chippewa and et cetera, that frankly, nobody works there anymore. It's either because they've either been fired, they took an early retirement, or they don't want to be a part of what is happening in this administration. So that statistic was, it used to be approximately 30 attorneys. Now only about 3 are left. Is that what you said?
That's right. Yeah, that department has been absolutely gutted.
I mean, but so Jacqueline, this is why these conversations are so critical. It's not just for the Native American community. I mean, if something happens to this section of the Voting Rights Act, it is going to become virtually impossible to be able to sue if your voting rights are abridged. So what is the position then from the government on this. I mean, it's just such an it just underscores the importance of voting, which I know is ironic because we're having this conversation about the Voting Rights Act, but it just underscores the importance of your vote to get people in office, like good presidents that do good work and good policies.
I do think that it underscores how powerful forces can be, and I will also say that the dismantling of the Voting Rights Act has been a decades-long effort.
Yeah.
Right.
Yeah.
The truth is that folks have wanted to cut out minority voters because either they ideologically do not believe that minorities should have a seat at the table, or they're simply fearful that minorities will eventually constitute a majority. Both of those things, right? I think we see in Indian country, like I said, in North Dakota, there's no chance that Native Americans are going to take over the legislature, right? They're just categorically opposed to any type of Native American participation, right? But there's also, a fear of the growing demographics that this country have, and we're certainly seeing a backlash. And I think that, sometimes we do, again, think of this just in terms of politics. But we cannot forget this is also deeply rooted in race, and that people fought and died for our civil rights, and that we have to continue to protect those civil rights and the avenues and legal mechanisms that we use to protect those civil rights.
Your brief also includes this bit of history that I really want to make sure that I amplify for people to understand when it comes to this Turtle Mountain case. Until 1922, the state of North Dakota denied Native Americans the right to vote unless they severed their tribal relations and adopted the dress, religion, and customs of white people. North Dakotans did not even elect a Native American to the state legislature until 1970. I mean, Jacqueline, it is a disgusting reflection of a lack of humanity to even try to force an entire group of people to have to abandon who they are, but to now suggest that they don't even have the one person, one vote kind of value is just mind-blowing to me. But part of it, though, is because, as you said, it's racially driven, it's partisan driven when it comes to parties. But some Native American votes have carried Democrats, for example, across the finish line in decidedly good ways in recent races.
Yeah, so Native Americans are actually incredibly powerful. Native Americans, if fully enfranchised, could be the deciding votes in places like Michigan, Minnesota, Wisconsin, Nevada, Arizona, New Mexico, right? Also Alaska, right? And we've seen those Native Americans flex political power in places like Arizona and Alaska. And in Alaska, it has to, it's in the case of Republican Lisa Murkowski, right?
Yep.
Who was a moderating candidate relative to an extremist far-right candidate. And Native Americans are savvy. They recognize what's in their interest and have been voting, I think, in a way that reflects that knowledge. And so, Native Americans, if fully enfranchised, would be a potent political force. But unfortunately, we're seeing those structural barriers that I talked about earlier, about how it's just simply too difficult to vote in Indian country. And then we're seeing the blatant discrimination against Native Americans that we're trying to combat. And yet, as you see, the tools that we use to combat the discrimination are being attacked.
How can people learn more about NARF, the Native American Rights Fund, and how can they show support for your organization and the fight that you are bringing on behalf of all of tribal countries?
Yeah, well, so, we certainly appreciate any support. Again, and one thing I want to say really quickly also is that Native American tribal sovereignty is not in conflict with racial discrimination. I think that's something that a lot of people don't understand or try to conflate. Native Americans are sovereign. They are governments in the same way that sort of states are governments. I can have citizenship of my tribe, the Isleta Pueblo. I can be a California state citizen, and I can be a United States citizen. None of those things are in conflict. And I can also be discriminated against on behalf of my race, right? And I think that Native Americans, so when we bring those suits on behalf of Native Americans and tribes, because of the racial discrimination that they face, that is not in conflict with the tribal sovereignty that we are fighting day in and day out to protect. And so to get back to your original question, that's there here at NARF. You can go to narf.org or vote.narf.org to learn more about our work. And we have a variety of videos that explain sort of the discrimination that we face when Native Americans try to vote. And we appreciate your engagement so much.
Jacqueline De León, thank you so much always for the privilege of your time. I have shared privately, and I will do so publicly. I am incredibly proud of the work that you are doing. I am grateful for your willingness to make me smarter and to make me a better advocate for your work, because I do feel like there's not enough light that is being shown on just how hard you guys are fighting. Y'all are fighting hard on behalf.
We win quite a bit, I gotta say. I'm very proud of our record here at NARF. Unfortunately, it's because our facts are so egregious, but we have a very high success rate, and we so appreciate you, Katie. You've always made time for us and really delved into the issues, and so appreciate it. Thank you so much.
Well, thank you so much for being here, and always feel free to come back and let us know what's going on, because it's really important, the work that you're doing. So thanks again, Jacqueline.
Thank you.
Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.